Welcome to today's webinar, Understanding Copyright, which is part of our series Getting Started with IP. My name is Fasiha, and I work in CIPO's Business Services branch in the Intellectual Property Awareness and Education team. Today, we are going to cover the basics of copyright, and by the end of this presentation, you should have a clear understanding of what copyright is and how it works. So before we start, you might be wondering what CIPO is and what it does. IP rights are territorial and managed by the intellectual property or IP offices of countries around the world. In Canada, it's us, the Canadian Intellectual Property Office, that is responsible for the administration of most Canadian IP rights. CIPO is part of the Government Department for Innovation, Science and Economic Development Canada, so we handle application guidelines, forms, and examinations used in the process of issuing patents, trademarks, and industrial designs. As well, we work on increasing IP awareness among Canadians. So as I mentioned, we work to raise awareness for the effective use of IP by Canadians. To this end, our IP awareness and education program delivers a wide range of products and services free of charge to help Canadians better understand the importance of protecting and managing their IP assets. We are a team of content writers, presenters, and IP advisors who can assist innovators, creators, and entrepreneurs in understanding IP before engaging in discussions with IP professionals, lawyers, or others where their IP will become a central point of the conversation. Therefore, we have the resources to explain what IP is, help people identify their IP and explain what type of IP right would be most relevant for different creations, explain how to protect IP, how to manage it effectively, and of course, where to get help. Our tools and resources are available on our website, and we also offer fact sheets, detailed guides, online learning modules, roadmaps, and more explaining the steps to register formal IP rights, including copyright. We also organize seminars and webinars, and it's also possible to arrange meetings with our IP advisors online or in person. So in today's webinar, we will start with an overview of IP rights and attempt to answer the following questions. What is copyright? What's the criteria for copyright protection? How can I make money from my copyright? And how can I avoid copyright infringement? As well, we'll answer how you can register for copyright and, most importantly, who can help you. So let's start with an overview of what IP actually is. Intellectual property is all around us. It's in the clothes that we wear, the coffee that we have in the morning, the electronic devices that we use every day, and the music that we listen to on the way to work. IP comes from a creation of the mind. It's the form that an idea takes when created that can be protected. A few examples of IP include inventions, symbols, logos, pictures, designs, literary and artistic works, and many other representations. IP rights encourage innovation by giving creators the exclusive right to prevent others from stealing or appropriating their invention. We find most businesses have some form of IP, whether it's formally protected or not. In business, IP can set one's goods or services apart from others and is referred to as property. Because just like real property, rights are acquired with ownership. Like when you own a building or land, you can sell it or lease it or keep others from trespassing into your space. Similarly with IP, you can sell it, license it, and exclude others from using it. And also like real property, IP is a valuable business asset. Here on the screen, you see traditional types of IP and the registered rights that are associated with them. So let's start with trademarks. A trademark refers to a sign that distinguishes one's products and services from those of others in the marketplace. A trademark can be a word, symbol, design, or even a taste, sound, scent, texture, and more. It's what consumers often first see and how they navigate the marketplace. It's really about being distinctive so that consumers can easily identify a trademark with the associated product or service. Trademarks also include geographical indications and certification marks. A geographical indication links a product or a service to a given place, such as a country, region, or an area. It informs consumers of characteristics or qualities due to natural or human factors for that location. Think of agricultural products such as wine or dairy or even handicrafts. Geographical indications can provide a way for businesses to protect their geographically unique products. Next, with certification marks, they indicate that a product or service meets certain quality criteria in order to comply with a defined industry standard. So, for example, a certification mark could apply to organic products, green technologies, food products from Quebec, Wi-Fi, and more. Next, with patents, it's all about applying them to functionality and providing technical solutions to a problem. It's the way you can protect new or improved products, machines, processes, and compositions. The invention to be protected has to be new to the world, useful, meaning that it must work, and inventive. Then, of course, there is also copyright, which typically protects music and artistic creations. Copyright is about original expression, creations that use some level of judgment and skill and are not just a mere copy of somebody else's work. Industrial design, on the other hand, concerns the appearance of an object. It serves to protect the unique appearance of a product and what appeals to the eye. This includes unique shapes, patterns, on clothing, fashion accessories, technological devices, etc. And lastly, we have plant breeders' rights, which protect varieties and denominations of new plants. However, CIPO does not manage the application process for these rights. That would be the Canadian Food Inspection Agency. So, IP includes valuable information, and it's important to note that there exists other type of IP which hold valuable information but that cannot be formally protected. A good example of that is a trade secret. A trade secret can be any business information that derives its value from secrecy. It can be a method, a technique, any know-how, research, analysis, data, a customer list, a formula, a recipe, and much more. It's some sort of competitive edge, but one that cannot be formally protected. Trade secrets can be incredibly valuable. However, they may not be the best choice of intellectual property protection if your competitors can easily reconstruct or reverse engineer your creation. Reverse engineering is when you recreate a product just by looking at it or seeing how it functions. There are other examples of non-traditional IP, like domain names and websites, which are not the same as trademarks, and social media accounts that actually contain a lot of IP, such as trademarks, copyrights, and more, and publicity rights as well. Moving on to copyright, what exactly does it protect? A copyright, once again, is a type of IP that protects original works of authorship as soon as the author fixes the work in a tangible form of expression. That is, the work is original and fixed to a material form. Copyright does not protect ideas. It instead protects original works which include literary, musical, dramatic, and artistic works, a performer's performances and sound recordings, and communication signals. It's important to note that copyright protection may apply to computer programs, which may extend to all of the copyrightable expression embodied in the program. Copyright protection prevents unauthorized copying of the code, but the copyright law does not protect the functional aspects of a computer system, such as the program's algorithms, formatting, functions, logic, or system design. If your software adds new, non-obvious functionality to a computer system, you should consider obtaining a patent instead of a copyright. Now, what does copyright provide you? Copyright gives the owner the exclusive right to produce, reproduce, publish, or perform any original literary, artistic, dramatic, or musical work. Economic rights are a set of exclusive rights that are granted to copyright owners and give them control over the use and exploitation of their creative works. They are a key aspect of copyright law, as they provide creators with the ability to earn income from their works and to control how their works are used and distributed. Moral rights protect the integrity of a work and the identification of its owner. This includes the author's ability to publicly name themselves as the author of the work, and the ability to choose in what context and in what association with which works or causes the creative work is shown. Now, in your opinion, which business assets here on the screen can be protected by copyright? Of course, it's blog posts and website content, which can be protected by copyright. So why don't the other choices fall under copyright law? Well, for the first choice, business or brand name, that would fall under trademark law and could be protected as a trademark. Then, with domain names, These are addresses on the internet and are operated by private companies, so they could also be registered as a trademark. And for the client list, some people believe that as soon as you write on a piece of paper, it is possible to obtain copyright protection. In reality, this is not the case. Compiling a list of clients does not require any creativity. Writing is merely a mechanical action and does not meet the requirements of creativity. And for this reason, the first three choices are not protected by copyright, and instead, only blog posts and website content from this list would be copyrightable. Now, it's really good that you know what can be protected by copyright, but what is the criteria for protection? In Canada, copyright protection exists automatically as soon as a work is created and fixed in a material form, provided that the conditions of the Copyright Act have been met. It requires three criteria. The first is originality, so the work must be original, meaning that it must be the product of the author's skill and effort rather than a copy of someone else's work. The second is expression. The work must be an expression of an idea rather than just the idea itself. Copyright does not protect ideas, only the form in which they are expressed. And lastly, fixation. The work must be fixed in a tangible form, such as a written document, a recording, or a digital file. The scope of protection for various intellectual property rights differs. In the case of copyright, it lasts for the author's lifetime or 70 years. And this applies to all works that are not already expired by December 30th, 2022. The change to the term of copyright protection will not be retroactive, meaning that it will only be extended for works that are not already in the public domain. In other words, if the copyright in a work has already expired as of December 30th, 2022, the extension of the copyright term does not affect these works. Canada is a signatory country to the Berne Convention for the protection of literary and artistic works. This is an international agreement that sets out minimum standards for copyright protection that member countries must provide to its creators. Some of the protections that the Berne Convention provides to creators include automatic protection. So copyright protection is automatic and does not require formal registration or other formalities. National treatment, where creators from one member country are entitled to the same copyright protection in other member countries as creators in those countries. Minimum standards. The Berne Convention sets out minimum standards for copyright protection, including the rights of reproduction, translation, adaptation, and distribution. Duration. The Berne Convention sets out minimum terms for the duration of copyright protection, which must be at least the life of the author plus 70 years. And lastly, moral rights. The Berne Convention recognizes that the moral rights of creators are important. This includes the right to be identified as the author of a work and the right to object to a derogatory treatment of a work. Now, how can we monetize copyright? With exploiting, you can use your own copyrighted works to make money, for example, performing your own songs or selling your own photos. You can also use copyrighted works to create merchandise which you can sell for a profit. You can earn money from streaming or subscription services if your copyrighted work is distributed through such platforms. Next, with licensing, you can grant licenses to others to use your copyrighted work in exchange for payment. For example, you can license your music to be used in a film or a television show, or license your photographs to be used in a magazine or an advertisement. And lastly, with assignment, you can sell your copyright outright to another person or company in exchange for a lump sum payment. This is common in the sale of books, music, and other creative works. Now, as we transition to the next segment, here's a question for you to consider. Any content on the internet is in the public domain, so I can use it. In your opinion, is this statement true or false? False. Many people are under the impression that since they found something online, this content must necessarily be free to share or copy. Well, that's not true, and you need to be careful. Just because you find published material on the internet doesn't mean that it isn't necessarily protected by copyright. In fact, it's now common practice for creators to publish a small C enclosed in a circle to announce to the public that the material is protected and not free to be reproduced without authorization. And what do you think of this? As long as I credit or source the original, my copy is legal. Is it true or false? False. The owner of a copyright has the legal right to completely control the conditions of reproduction of his or her work. This means that only that person can grant permission to someone to copy his or her work, even if that person quotes the original author. Without such permission, this remains an illegal reproduction of copyright. Now let's discuss copyright infringement. Copyright infringement occurs when a person wrongfully uses your work without your permission or does anything only an owner is allowed to do, as stated in the Copyright Act. Infringement may include acts such as copying, performing, selling and distributing, or posting your work on the internet without your permission. Also note that copyright infringement occurs when any substantial part of a copyrighted work is reproduced without the consent of the owner. The responsibility of monitoring and enforcing the lawful use of your copyrighted work is left to the copyright owner. If you believe that your copyright has been infringed, it's recommended to seek the legal counsel of an IP lawyer to look at options and remedies. For example, you could get the infringer to cease the infringing activities and potentially be ordered by the court to pay you monetary damages. You can indicate copyright by putting a copyright symbol, the C enclosed in a circle as you see towards the right side of the screen, next to the title of your work. Under copyright law, a work does not need to be registered and the symbol is not required to appear on the work, nor is any other reference to copyright protection. Automatic protection is the law. However, marking a work with the copyright symbol and the name of the copyright owner may be required for certain remedies to be available if your copyright is enforced against others. Now let's talk about the exceptions to copyright protection or alternatives. In the public domain, works that are no longer protected by copyright are considered to be in the public domain and can be used freely without permission or payment. Next, with fair dealing, in Canada and the United States, the law provides for exceptions to copyright for purposes such as criticism, comments, news reporting, teaching, scholarship, or research. The term fair dealing isn't really defined in the Copyright Act. Instead, it is a legal test determined by the courts. And lastly, we have the Creative Commons licenses. These are a set of standardized licenses that allow creators to easily share their works with others under certain conditions. These licenses were developed as a way to promote open access and open content by allowing creators to grant permissions for others to use their works in ways that would otherwise be prohibited by copyright law. For example, non-commercial use or the creation of derivative works. And now, how can you use your copyrighted works? To use a copyrighted work, you generally need to obtain permission from the copyright holder. So the first step would be to try and get in touch with that person. You could start with a basic internet search, so look up their name on Google or on social media, and you can also try to search for your country's copyright registration database to determine whether the copyright has been registered. Remember, however, that the copyright registration is not compulsory, so it's highly possible that the author will not be in the database. Obviously, if the work is published, you can contact the publisher, or if the author is represented by a collective society, you can contact them instead. Then finally, if you can't find the copyright owner, you can contact the Copyright Board of Canada and request a license for copyright owner not found. You should document any efforts you make to locate and obtain permission from the copyright owner, as this may be useful in applying for a license for copyright owner not found. Now, don't forget the exceptions that we just saw on the previous slide, since these exceptions may allow you to use copyrighted works without having to obtain permission. If you're in doubt, you should always contact an intellectual property expert. Now, is it mandatory to register one's copyright? The answer is no. It's not mandatory to register your copyright. So as a general rule, copyright registration is limited to creative works. Facts and ideas are not eligible for copyright, nor is anything that has already been placed in the public domain. Your work should be complete at the time of registration. An application for registration must be submitted to the Canadian Intellectual Property Office if you wish to obtain an official registration via our website, or if you prefer, you can complete the form by mail or fax. The entire application process up to registration is covered by a flat fee, which is $50 when submitted online and $65 for all other cases. Now, it's important to note 3 things. First, CIPO only registers the information that you provide and does not verify the content of the information. Second, copies of your work cannot be stored at CIPO and will be returned to you if you send them. And lastly, remember that copyright registration is not mandatory and has no impact on your copyright protection. So why should one register a copyright then? Well, registering your copyright with the Canadian Intellectual Property Office entitles you to a registration certificate, and this certificate of copyright registration is incredibly valuable. It provides a public record of your work, which can facilitate licensing or support your ownership claim in the event of litigation. It also provides greater certainty for the administration of a request for assistance, or an RFA, with the Canada Border Services Agency. Then, of course, public registration can act as a deterrent to potential infringers. Registering your copyright can make potential infringers more likely to respect your rights if they know that you've taken steps to protect them. And lastly, it helps the public to find you, so it can facilitate licensing and more. It's really important to keep your address up to date. Keep in mind, however, that CIPO does not verify or examine claims made in applications for copyright registration, so the validity of the registration may be challenged in court. Overall, while registration is not required for copyright protection, it can provide additional benefits and protections that may be useful to you as a copyright owner. Please also note that postal dating is not considered an adequate substitute for official registration. Next, here are some more common misconceptions about copyright. For the first statement, I can copyright my domain name. The answer is, of course, false. We saw earlier that you can't copyright your domain name, however, you could register it as a trademark. Next, it's not copyright theft if I don't make money from the copied material. That's not true. That's a factor that might be taken into consideration when trying to decide if the dealing was fair to the fair dealing exception. We saw that infringement is copying someone's work without the consent of the author or of the copyright owner. It's as simple as that. And lastly, if the work doesn't have the copyright symbol, it's free for anyone to use. This is also false, as we've seen that it's a good idea to use the C symbol, however, it's not required, and it does not mean that you can still copy something that doesn't have the C symbol. Now, all of the resources, materials, and tools that I've talked about contain a wealth of useful IP-related content and are available in different formats such as audio, video, text, and interactive formats on our website. We are happy to guide you and give you as much information as possible on IP rights, but we cannot, however, provide you with legal advice. And unfortunately, all of the questions that you see on this screen are questions that require a legal opinion. So you might also require help in understanding complex IP topics, obtaining legal advice in the case of infringement, or seeking an opinion on strategic positioning and searching advanced databases. To that effect, there are groups of people and associations of IP professionals that you could turn to. To locate a licensed IP agent near you, you can contact the College of Patent and Trademark Agents, or CIPATA, which is a newly formed organization responsible for the management of IP agents. We recommend that you only deal with IP agents that are on the CIPATA list of registered agents, as those are individuals that have passed IP-related exams, are regulated, and are disciplined by the CIPATA. Unfortunately, there are individuals out there who will try and pose as an IP expert while they do not have the required credentials, so it's really important that you stay diligent and that you consult the CIPATA website to make sure that you know who you are hiring to assist you with your IP rights. And lastly, the Intellectual Property Institute of Canada, or IPIC, and the Bar Association are professional associations where you can also find IP lawyers or more IP professionals. Please don't hesitate to contact us if you have any questions or need help finding any of our resources on the website. You can reach us via the contact information that you see on the screen. You can also contact our intellectual property advisors for a more specific and tailored discussion to your needs by scanning the QR code on the screen. And for general questions about IP, you can reach out to our customer service center by phone or by email, and the toll-free number is also provided on the screen. I invite you to follow us on social media. We are on Facebook, YouTube, LinkedIn, and X. And finally, I also recommend exploring the CIPO newsletter titled IP for Business News, where you can find more information about new IP products, seminars, webinars, upcoming events, updates to the CIPO website, and more. So this concludes the webinar on copyrights. I hope you have learned more and enjoyed this presentation. And to learn more about the other topics related to intellectual property, I invite you to watch our other videos and to register for our live webinars on our website. Thank you so much for watching.